Hello, everyone, and welcome. We will get started in just a moment. Hello, and welcome to day 3, our final day of Alt Legal Connect. I'm so glad you're here. Thank you so much for joining us. This session is the USPTO Updates. USPTO representatives explain recent and upcoming changes. For those of you just joining us, my name is Bree Van Til. I am the Director of Education for Alt Legal and the Master of Ceremonies for Alt Legal Connect. I'm here to make sure you have a wonderful time and that you learn a ton. So if you have any feedback for us, please put that in the feedback form just to the right of this page, right next to the chat. Um, also, since it's a brand new day, I do want to remind you about our code of conduct. We're not going to tolerate any rude or harassing or bullying behavior. I know I have a wonderful audience. I know that you won't do any of those things, but let's keep that in mind, please. Please note that we are offering CLE credit for this session through the state of California. However, you must be attending the session live in order to qualify. I need you to be present for the entire 70, that is 70-minute presentation. I need you to write down the code when I give it to you. Don't try to memorize it. It does need to be exact. There will be no spaces in it. And we will send a survey at the end of the session, and we're going to put that code. I want you to put the code in the survey and submit that. So again, this should go without saying, but Alt Legal is a legal technology company. We are not a law firm, and nothing said here should be considered legal advice or anything like that. The upcoming presentation expresses the views of our two speakers, and you know what? They're super knowledgeable. They're going to help you a ton. They might not be the same views that Alt Legal has, however. We are different beings. All right, please do use the chat to talk amongst yourselves. If you have any questions for Dan or Amy, you can put those in the chat. Please just put the word question in front of them so that it's easy for us to know that we need to get those over to them. All right, I am pleased to welcome our speakers, Amy Cotton and Dan Vavonese. Amy Cotton is the acting Deputy Commissioner for Trademark Examination Policy at the USPTO. She oversees Trademark Policy Office, Quality Review, Outreach, and more. She joined the USPTO as a trademark examiner in 1998 and led the US delegation to WIPO for about 2 decades. Dan is the Deputy Commissioner for Trademark Operations at the USPTO. He leads the team in all aspects of trademark examination, registration, and maintenance. He's also been with the PTO since the 90s and also began as a trademark examiner. So they both understand trademarks fully and will be here to answer any questions that you have. Here are Dan and Amy.
So good afternoon. Again, my name is Dan Vavonese. I'm the Deputy Commissioner for Trademark Operations, and we're happy to be here today to give you an update on trademarks, both on the operations and policy side, to talk about filing surge, to talk about register protection, to talk about TMA. So my part, I'm going to give an operations perspective on what's happening in operations, and most specifically, the focus is going to be on the huge filing surge that we've had over the last approximately year and a half, and how that's impacted our timeframes, how it's where those filings have come from, and then what are we doing about it moving forward. So again, this is the focus again for my part of the talk is going to be on the surge. So I want to start with giving a little background on filings over the last approximately 10 years. And this chart shows monthly filings over the last 10 years. And what's happened is that, you can see that we have had a steady but gradual increase in filings over the last 10 years. We've had rises and falls month to month, year to year, but generally it's been an increase. And then we had an increase last fiscal year of about 9.5%. But there's a story behind that. When the pandemic's, we had projected about a 7%, a little less than 7% increase last year, and then the pandemic hit. And in the first couple months of the pandemic, in first quarter of FY20, a little bit further into that, we saw big drops in filings. And the projections in the economy were that the economy was going to continue to drop. We mirror the economy. If the economy is doing well, filings go up. And likewise, if the economy drops, our filings generally go down. And what happened was at the beginning of the pandemic, our filings went down. We projected we were going to have a drop by the end of the fiscal year as a result of that. We actually delayed hiring a new examining attorney class based on those projections. And then something interesting happened, and come about May of last year in at 2020, filings started going up, and then they kept going up, and then they kept going up. And throughout the summer and into the fall, we saw large filing increases, which you'll start to see by the higher lines at the top right of the graph here. July of 2020, and especially July, October, and in December of 2020, we saw huge filing increases. Um, we were averaging in the 60,000 per month range. We started getting up to 70,000, and then in December of 2020, we had 110,000 application filing classes, which is just an unbelievable number for us. We have 700 examining attorneys that are examining these applications, and we're hiring, and I'll talk more about that. The increases, you've probably heard about increases coming from China, but we had huge increases coming within from US filers as well. There was a huge increase in e-commerce last year, and it's just continued. We've had everything from brand registries have gotten involved in requiring trademark registrations or applications to validate that the business is valid. And the other thing we've had is huge rises in one-time filers. So small filers, either one application or no more than 10 applications. That's been a huge increase as well. So there's been a lot of reasons. It's not been a single source for where our increases have come from. Over the last couple months, we've seen a smaller drop in our filings, back to around 70,000 or so, or high 60s. But I just want to emphasize that if you hear about our filings are dropping, they may be dropping, but it's just relative compared to what we've seen over the last year. They're still huge filings for us on a monthly basis compared to how we've seen them in the past. And our projection for this year is to end up around 940,000 classes, which would be a 27% increase over last year, in which we saw a 9.5% increase. And we really project moving forward to see similar filing increases in the 7 to 10% range. Again, it depends on the economy, but that's what we're probably seeing moving forward. And that's already on top of a baseline of over 900,000 classes moving forward. Where are these applications originating from? We break this down in four ways. We break it down at the top blue line is the US, where we're close to 59 to 60%. China is the orange line, which is around amounting to about 25 to 26% of our total filings. And you'll see it's more of a rise, dip, and increase depending on the time of year. Especially at the end of December of last year, you saw a big increase coming from them as well. And we also had a fee increase at the beginning of this calendar year, which was another reason for the big filings at the end of December. The gray line is the European Union, and the green line is the rest of the world. And they've been pretty steady. You don't see big rises, but it's those together, that's another 16% or so of our filings. We've seen a slight drop from China in the last couple months, and a slight drop in US, but generally, these numbers are about consistently where we're continuing. So what has that done to our inventory? This graph shows over the last 5 years how our unexamined application inventory is. And we have generally been in the 150,000 application class range. Again, across 700 examining attorneys, that's a very comfortable inventory for us. It has allowed us to stay in our 3.5 month first action pendency range, which is something that we've been maintaining for the last almost 15 years. You'll see that come about summer of 2020, when the filing increases happened, our inventory went up. We are now close to that number. We had to submit these slides a little while ago, so our inventory is actually closer to 490,000. We are hoping that, between the filing drops and between some additional things that we've been doing, that we're going to start to stabilize and stay below the 500,000, and then we can hopefully start to eat into that inventory. And what does that mean for our first action pendency? And that's probably the biggest question you have here, is what's going on with our pendencies. We measure, as far as new applications, both our first action pendency which is the time from when the application is filed until the first office action or the first determination is made by an examining attorney. That's first action pendency. And then disposal pendency, which is the final determination on the application, which is generally either approval for publication or abandonment of that application. We have seen considerable increases in our first action pendency, which many of you know. We're actually close to 6 months right now in first action pendency. We are working extremely hard on that. And our productivity from all of our examining attorneys continues to be about where it's been in past years. They've been, throughout the pandemic, they've been continuing to work and get through as many applications as they can on a daily and weekly and monthly basis. It's just been this huge inventory of work that we're having a hard time getting through. But we are trying, and I'll talk to you in a couple minutes about what we're doing about it. The green line is our disposal pendency. We've generally been in the 10-month range. Our goal is to keep it below 12 months. We're at about 11 months now. We still anticipate continuing to stay below that 12-month goal to have a final determination on the case. So this surge has impacted us not only in our in our application examination within the law offices, but in all other areas of our office as well. We Especially earlier in this calendar year, we had some major impacts across all areas, especially in our services areas. We have started to get back on track on those. I wanted to point out a couple things here. So first, there's been some questions about uploading new application data into both TSDR and into TESS. All of the data that is submitted within a new application is processed and entered into our systems within 1 week. It is taking up to 2 months to get the office supplied data into the system. That's design codes, pseudo marks, some of the additional quality checks that the office does. The one issue that we're seeing is if an application does not include the international class. So that would be for a TEAS regular application where the class field was left empty. That is the one time where the data can't get entered into the system, because that we need our pre-examination unit to review those applications and add a class before all the data can get in. So we put some reminders on our website. Please, if there's anything you can do, make sure that if you're filing a TEAS regular application, to include the international class in the application to ensure that your data will get in there as soon as possible. Amendments and responses to office actions. That was another area that earlier in the year we really took a heavy hit. We could not keep up with the amendments and responses that were coming in. We were actually closer to 90 days to have the responses entered by our examination support unit and into the system, so that the examining attorneys got those responses. Over the last couple months, we have made huge progress here. We're back under our goals of 14 days. So any responses that are being filed, they are back. The backlog is done, and they're back under 14 days. So when you file your response, you should see the response going to the examining attorney back within the 2-week time frame that we've come to expect. So that's been a huge accomplishment for us. I want to also emphasize that, with all these time frame issues, we have made our huge focus of ours has been to post all of our processing times on our website on our USPTO.gov. We have created. I'm going to move on to the next slide. We have if you go to our trademarks homepage and you click on the processing timeframes link, you'll be able to see what our timeframes are in our various different units. This includes in pre-exam, in exam support, intent to use. And I want to also mention post registration because not only we are seeing over a 10% increase in maintenance filings as well. That has also led to a backlog in post registration. We're closer to 70 days right now in processing Section 8s. And we'll be working closely with our post registration area to eat into that backlog as well. So, what are we doing to try to handle the surge? Um, we have been doing a lot of reorganizing of workloads among our professional staff, and that's again to deal with our services areas, backlogs. That helped a lot in our exam support unit and in our pre-examination unit to get our amended backlogs down. And now we've been cross training so that we can get additional assistance in our pre-exam unit to get our timeframes down in there as well and to get the office supplied data into the system. We have also hired in both areas as well to assist with that work. In the law offices, we hired 47 new examining attorneys earlier this calendar year. They are fully trained now, and they are on production, working on all of our applications. So that's a huge boost to us. That additional workforce to help. We will be hiring up to 100 new examining attorneys in this upcoming fiscal year, and we're through the interview process right now. So we'll be bringing them on in the fall. We do expect similar numbers over the next few fiscal years, assuming that the filings continue on this pace. We are looking at all areas of our examination process and where we can improve efficiency. We're going to be looking at our entire process and where we can streamline, where we can automate some of our processes. And there was a question that came in about the 6-month time frame, and is it a short term? Is it a long term? We're going to do everything we can to get that time frame back down. But that said, it is going to take a while. This is going to be with us. You saw that huge inventory. We're not going to bang it out because, as you'll hear from Deputy Commissioner Cotton, we have huge register protection initiatives. We need to be smart about how we're doing this. And we also, the 6 months gives us some additional opportunities to do more review, analysis, investigation up front before the application gets to the examining attorney, so especially in the bad faith areas, we can handle some of that work before it gets to the examining attorney, so it's ready to go when the examining attorney sends their first office action. On the IT side, we are also looking at some robotic automation as well as artificial intelligence. We're starting in our services areas again. We have a design code artificial intelligence tool that we're working on to assist our staff with signing design codes. That's something we'll be looking to test out and hopefully implement this fall. And that should really help with streamlining and that part of the process. And these are kind of test cases for us, and we hope to use more bots and more artificial intelligence to assist with administrative tasks throughout all of operations. I wanted to mention quality because we have 5 strategic goals. The two pendency strategic goals are, I've said, our first action and disposal. We have 3 quality goals in first action compliance and final action compliance, which are, did we make the right decision on a statutory issue on a given application, and then exceptional office actions, which is kind of a holistic look at the entire file. Did we do the right search? Did we put the right amount of evidence? Did we put the right analysis and arguments? And then still, did we make the right decisions on the case? I'm happy to say that even with all the challenges of the pandemic and the filing surges, and with the register protection issues, and especially in bad faith, we continue to maintain all of our first action goals, and we're actually far exceeding them. So again, it's a credit to our examining attorneys to continue to work through all of these challenges and continue to meet these goals. We got a couple questions in about inconsistency. I wanted to just mention that, across 700 examining attorneys, this is a challenge. We train all of our examining attorneys on looking at companion applications and making sure they're consistent in how other applications filed by that same applicant are treated. We look for common issues, and we train our examining attorneys in those areas. If you see inconsistencies, you should feel comfortable to reach out to the examining attorney and point out where that inconsistency is, and they will take a look at it. As well as, if you're still not happy with the result, you could always reach out to the managing attorney for that examining attorney to raise the issue as well. I just want to mention, with respect to inconsistency, that each application is examined on its face, based on the facts of that case. Differences in IDs, differences in the specimen, differences in other aspects of the application can yield different results. So that's something, please, to keep in mind. But I just wanted to make sure everybody understood we take inconsistency very seriously. Just on the communication standpoint, I already mentioned this. We do have a trademark dashboard. Again, if you go to our website, to the trademarks page, you will see our monthly pendency metrics. It will give a yearly and quarterly statistics. We are posting notices constantly on our website where we are in our processing timeframes, and we've been doing blogs. We've been doing additional tips to our customers to help them with navigating the filing, navigating tips in order to have their application proceed more quickly through the process. I'm seeing some questions in here, and I'm gonna move on to Amy to make sure that she has time coming in, and then at the end I'll come back to try to address some of the last few questions. So thank you very much.
Okay, we're moving on to the second half of our presentation. I've got a lot to tell you, and I want to share our timeline of going back to 2012, actually, on our register protection initiatives, but I couldn't fit it on the page, so we're going to start here. If you all remember, if you're old like me, you remember the In re Bose decision and how impactful that was in 2009. It came out of the Court of Appeals for the Federal Circuit, and it made it more difficult to prove that a false statement of use should be considered fraud. And a finding of fraud would void the tainted class in the application or the registration, but it would establish a clear sanction for making false claims of use in submissions. Now, we were concerned back then that the impact of the case would be that we would see more false claims of use in maintenance submissions and in applications. So in 2010, the USPTO convened a roundtable along with George Washington University. We called it the Future of the Use-Based Register. We wanted to see if stakeholders shared our concern that we were going to see more and more false claims of use, and therefore then if use isn't something that people want to subscribe to, then maybe we need to look at a different system here. But the stakeholders agreed with us that use was really critically important to the register and how useful it was for making business decisions. So during that roundtable and the years following that, we came up with a variety of different suggestions for changes we could make to our own system to increase the duty of care for applicants, and we wanted to disincentivize inaccurate statements. Stakeholders, though, of course, rightly indicated a significant concern that changes to address this behavior might make it harder for good faith filers to use the system. So we went very slowly and deliberately and started poking at the issue to see what we could do. In 2012, we started measuring the volume of inaccurate claims of use in Section 8 and 71 declaration filings through our proof of use audit program. We made that program permanent in 2017, the first of the events on our timeline here. But the audit program really had a limited effect, in my view, because we did not originally impose a sanction for filing a false claim of use, other than just deleting it out of the registration, and the registrant went on their merry way. Now, compounding that sad state of affairs, that we were ending up with significant deletions in the audit program, around 2018, 2019, we started seeing an increase, not just in false claims of use, but in a lot of other things. So around the same time that our filings were significantly increasing, we started also seeing filings with fake names, fake addresses, fake specimens of use, and suspicious attorney behavior. We were seeing behavior that appeared designed specifically to circumvent our rules of practice, our rules of representation, our rules of professional conduct, and our website terms of use. So our slow and conservative start to protecting the register from these false claims of use in 2012, it really needed to accelerate and expand to other types of behavior. And you'll see that acceleration in this timeline on the slide. So in 2019, and we're going to go through all of these specifically, but let me just run through them quickly. We increased the scrutiny of specimens of use. We stood up a task force, a special task force that's responsible for investigating improper behavior and scams. In 2019, we followed the practice of most other countries and started requiring foreign domiciliaries to be represented by a U.S. licensed attorney. In 2019, we went with phase 1 of our login project that allows us to better track filing behaviors through the use of USPTO.gov accounts. But this wasn't enough. We were still watching our filing numbers increase, and we were still seeing suspicious filings. So in 2020, we shifted our mindset, the register protection mindset, more aggressive. We started thinking like a brand owner that deals with anti-counterfeiters, and we started thinking about sanctions. So in 2021, we implemented a deletion fee for any goods and services deleted in the context of examination of the maintenance filing, including within the audit. 2021, we started issuing administrative sanctions against actors who are intentionally violating our rules. In 2021, we're now still preparing to implement provisions of the Trademark Modernization Act. It's the latest in the series of tools that we are using to design to increase the accuracy of the submissions that we receive coming in and the resulting integrity of the U.S. Register. So let me tell you about these individually. So the post-registration audit, as you know, this was where we were testing the accuracy of the claims of use made in maintenance declarations in Section 8 and 71 declarations. So, of course, a registration would be audited if it meets two requirements: if the Section 8 or 71 declaration was filed, and the registration includes at least either one class of 4 or more goods or services, or 2 classes with 2 or more goods and services. So that office action will invite the registrant to provide proof of use for 2 additional goods and services per class. If the registrant does not either, 1, provide proof of use for the queried goods and services or delete the queried goods and services, the examiner will issue a second action, request more proof of use on additional goods and services in that same class. If the registrant deletes the queried goods and services, the registrant must pay a deletion fee of $250 per class in response to that office action. This is a new feature in both the audit program and all post-registration examination. This started in 2021. It is a sanction for a false claim of use. Anytime you delete in the context of the maintenance examination, you have to pay that fee. And if you fail to pay it, you could lose the entire registration. How do you avoid this penalty? Keep your registrations accurate as to those goods and services for which the mark remains in use. Use the Section 7 amendment process to keep your registration accurate. Now, in 2019, the audit program and the deletion fee were aimed at maintenance filings. So we wanted to likewise increase the specimen of scrutiny of our specimen of use that were coming in applications. So we established a policy in 2019 with guidance that a fake, which is a digitally altered or created specimen, it creates an inference that the mark is not in actual use in commerce. Now, while this might be obvious, this was a significant policy shift for us because it allows evidence of non-use to be considered in examination. Now, we've had examination guidance dating back to 2014 on digitally created specimens, but it was really focused more on making sure applicants provided us with the right kind of specimen, not whether they were trying to fool us. So the guidance then emphasized substitute specimens that better showed the mark as it is in use in commerce. But that really wasn't cutting it now. In 2018, 2019, we started seeing clearly fake images. And because we were allowing substitute specimens to overcome every specimen refusal, we started seeing better fakes. So in 2019, our guidance told examiners to refuse the application when an image was clearly fake, and then they should also follow up and probe requests for information to make the applicant prove that the mark was actually in use. Now, in that 2019 version, we didn't allow the applicant to respond to the refusal with substitute specimens or to amend to 1B. We forced the applicant to respond to the request for information, the RFI. There was some backlash from both our stakeholders and our examining attorneys that we were going too strict on good faith filers. They were getting caught up in this. So in 2020, we issued a revised guide that allowed applicants to respond to the refusal and the RFI with the substitute specimens or by amending to 1B, but they did not have to provide the proof of use in response to the RFI. Now, we also wanted to expand our letter of protest system, because if we're considering non-use in examination, we should also consider non-use in the letter of protest procedures. So as a reminder, the letter of protest, typically third parties cannot provide or intervene in someone else's trademark application without filing an opposition at the Trademark Trial and Appeal Board. But the letter of protest procedure allows the third parties to send evidence to the USPTO regarding another's application. So we review that evidence from the third party. We determine whether the evidence is relevant to a ground of refusal. If it is, then we will forward that evidence to the examining attorney for consideration. Because our examining attorneys were not historically issuing refusals for non-use, just the bad specimens, we did not allow letters of protest to address that non-use, but now we are. Now we've expanded the evidence we'll consider in a letter of protest related to specimens. We will now consider evidence that the third parties are using the same image without the trademark, evidence that the image appears in multiple prior registrations or applications, all bearing different marks, evidence that a specimen was digitally created or altered, or evidence that demonstrates that a specimen was not in use on or prior to the date it was submitted. So if you recall, some of these were in our specimen protest mailbox. We had a specimen pilot program that we were using. We closed that program, moved it into our regular letter of protest procedure, and then expanded everything that we were taking in the letter of protest procedure to accept this evidence of non-use. Now, we won't take evidence simply that you can't find the product on the internet unless you have other evidence of non-use that we can look at as well. I would definitely encourage you all to find the webpage we have. It's called the Letter of Protest Practice Tips, if you want more information about what we will accept in a letter of protest and what we won't. So that's certainly something I want to draw your attention to. Okay, now, anytime a new filing trend emerges, we give our 700 examining attorneys the legal policy guidance to try to handle it. And so for years, they've been on the front line of our battle against these individual bad faith actors. But what we're seeing now are larger schemes and scams in all kinds of trademark filings, and our individual examining attorneys are not in a position to spot these trends and respond with a coordinated action that really affects thousands of applications. So, for example, a fake specimen will come in large waves of virtually identical specimens in applications listing all kinds of different owners. And because those owners differ, then these are not grouped as companion applications where one examiner would handle them all. They're all different owners. So it makes it difficult for our individual examiners to spot these trends and handle them consistently. So we stood up a special task force in 2019. It's got attorneys from Trademark Operations and Trademark Policy, but they actually coordinate investigations across the whole agency with different personnel. So what are they investigating? They're investigating false claims of use. Applicants or registrants that are claiming use for which they cannot establish that use in commerce, and these are in applications and maintenance filings. We are investigating filing firms or applicants that submit doctored or fake specimens that do not demonstrate use of the mark in commerce. We are seeing U.S. counsel circumvention, applications featuring false attorney names or false U.S. addresses that are designed to circumvent the rule. We're seeing submissions where there's a real U.S. attorney name and credential, but the attorney is actually unaware that their name is being used. They don't have a representation agreement. We're seeing offers to rent U.S. attorneys' bar credentials to circumvent the U.S. counsel rule. We see unauthorized practice of law. U.S. and foreign non-attorney filing firms are engaging in unauthorized practice of law. They're providing advice and appearing in submissions before the USPTO when they're not authorized to do so. We are seeing filing firms that are forging signatures on submissions. We're seeing trafficking in applications or registrations. We see applications or registrations that are hijacked through unauthorized changes of correspondence addresses in our records. We see brands that are hijacked through unauthorized applications. They use the accurate company information, but they have a different or unauthorized correspondence address that's getting information from us. We see applicants stockpiling registrations for their own use on e-commerce platforms, storefronts, or we see offers to sell those to third parties for the same purpose. And of course, we're seeing scam solicitations. These are the solicitations that are meant to appear that they originate from the USPTO. They use USPTO public information to dupe applicants or registrants into paying for services that they don't need or that they never receive. So our investigators are looking at all of these different schemes that they've got. They'll take in reports of suspicious filings from a variety of sources. We've got examining attorneys who will report through an internal mailbox about things that they're seeing. We'll have our data analytics folks spot trends, different IP addresses that are being used or that sort of thing. We will hear from law enforcement who are investigating criminal behavior, and they will come to us for information. So then we hear about it that way. We hear media reports, same as you. We'll hear about things that are affecting U.S. applicants, and we bring that internally. Certainly, we get customer complaints. We get that through our Trademark Assistance Center. We get it through a mailbox that we have, tmscams@uspto.gov. So if you see something, you can certainly send us an email at tmscams@uspto.gov, and we will have our investigators look at that. We hear about things through the petitions to the director or letters of protest. So our investigators will look at the fraudulent activity, and they're trying to determine the nature of the misconduct based on the information that we have. Sometimes you've got applicants who just misunderstand U.S. rules. Those cases we can just handle with our examining attorneys. They know how to deal with applicants that don't quite know what they're doing. Now we have other situations where it is clear that they're trying to circumvent U.S. rules or abuse our electronic databases, and those folks can be subject to administrative or criminal sanctions. So we have 3 different avenues for sanctions against bad actors after we look at it, investigate the behavior that we're seeing. So number 1, we've got the Commissioner for Trademarks authority to sanction violators of our rules of practice. We've got the Office of Enrollment and Discipline. They have authority to sanction violators of the rules of professional conduct. And then, of course, we've got law enforcement authority to pursue criminal prosecution of those that are violating criminal laws, including perjury laws, which under the declaration that is submitted with the applications, you have to sign that under penalty of perjury. That's a criminal provision that is under the auspices of law enforcement. Of course, the first one is the one that we have the most control over within our task force, the Commissioner of Trademarks authority to manage and direct all aspects of the activities of the USPTO that affect the administration of trademark operations. So this includes the authority to sanction parties who file submissions in trademark matters in violation of our rules. As part of our investigation process, we collect evidence and we decide whether we should, pursue sanctions, whether we should refer the matter to OED or we should go to the law enforcement option. So our process. If we identify a scheme, we start pulling affected applications off. We sequester those. If they're unassigned, we put them in holding dockets. If they are already assigned to examining attorneys, we ask them to hold to suspend action on those applications while we collect evidence and we figure out what rules we're talking that have been violated. And depending on the violation, depending on the nature of the violations, we have 2 options. We can certainly direct our examining attorneys to issue the appropriate refusals or requests for information, or we can go the show cause route, the administrative sanctions route. The show cause order starts the process. It directs the offending party to explain the conduct that appears to us to violate our rules. We identify potential sanctions, and we set a deadline for response. That response comes into us, if one is filed at all, and then we might issue an order for sanctions depending on what we heard. The sanctions would include not considering or giving any weight to an affected submission. It could be terminating a proceeding before the USPTO. This includes terminating applications. It could be that we're going to preclude a party from filing on behalf of themselves or others in any trademark matter before the USPTO. It could be, like I said, we could refer practitioners over to OED. And we can terminate USPTO.gov accounts through all the electronic forms have to be filed there, so we can terminate the account through which you can file. Now, if we see that a representative, an attorney representative is implicated in these applications that are featuring rule violations, we will collect evidence and we will refer the matter over to OED for investigation and possible discipline. Now, OED investigates suspected violations of the rules of professional conduct by attorneys that are appearing before the USPTO. The OED director may issue warnings, institute formal charges against the practitioner, or enter into a settlement agreement with the attorney. And of course, the OED also has the authority to refer an attorney to a state bar for reciprocal discipline. Now, again, for criminal activity, we go through the Department of Commerce's Office of the Inspector General, who then may talk to other law enforcement agencies. Now we are moving on down the timeline. In 2019, you all remember the U.S. Counsel rule. Foreign domiciliaries must be represented by a U.S. licensed attorney in trademark matters before the USPTO. All applicants must provide their domicile address, whether they're represented or unrepresented, and that's how we figure out whether the U.S. Counsel rule is triggered. So just simply because an applicant is represented does not mean that they can get out of providing the domicile address. That must be provided. So the U.S. Counsel rule, we find that there are those who are trying to circumvent it. We see the fake names and the fake addresses. We also see fake attorney names, real attorney names, which I said where the attorney has no idea they've been compromised. We have seen the credentials renting the credentials. I want to go to the unacceptable addresses, right? This is, where we get those fake addresses that are designed to try to get around the rule. We are working on ways to automate checks on the addresses. So we've got a flag for PO boxes, for care of addresses, for commercial mail receiving agencies, those are all unacceptable addresses. We flag that for our examiners so that they remember to inquire about it and get the domicile address. And then we know whether the U.S. Counsel rule is triggered. Certainly, we're also looking for ways to automate address verification during the application stage if we can. Now, as for the attorney misconduct that we're seeing, where we're seeing the folks hijacking, U.S. attorneys' credentials, we are collecting evidence. As I said, we're referring it to OED where we find that, and trying to make sure that the attorneys who are appearing before us are following our rules. Now, the next initiative on our timeline is the mandatory account login. In 2019, USPTO Gov accounts were required for filing NETs forms. That actually allowed us to start tracking a lot of behavior. Of course, then if we close out one account because of bad behavior, certainly another account can pop up. So we want to move on to phase 2, which is identity verification. That is currently in beta testing. We will be rolling that out in the next year. And you all will be hearing much more about it. We're partnering with ID.me to verify the owners of USPTO.gov accounts that are used to file all our forms. Once we can verify those identities, again, we can terminate an account and then prevent it from popping up again once and if sanctions are levied against a particular actor. Now, phase 3 is role-based access controls. We are planning on assigning a limited number of roles to control and delegate access to TEAS form filings. Only authorized customers will be able to file a TEAS forms related to that application or registration, and this will stop the unauthorized changes of correspondence addresses and the hijacking that we're seeing. We don't see a huge amount of it, but certainly it's a real nuance and a lot of manual labor to try to fix those. So we're hoping that our login phases will help with that. So now I want to get to the last stop on our timeline. It's actually not our last stop, right? We're going to keep working on initiatives, but the most recent initiative, the most prescient one we're working on right now is the Trademark Modernization Act of 2020. So in 2018, 2019, we were faced with that surge of applications that had the sketchy specimens in it, and Congress, hauled us up for a hearing and asked us, "What do you need what do you need from us, from Congress, from a statutory side, to address this overall concern of false claims of use in trademark applications and maintenance declarations?" So we had three asks at the time. We asked if the letter of protest procedure could be codified so that we could have the clear authority to charge a fee. We were seeing more and more of the letters of protest. We needed to cover our costs, make sure that we were able to continue to provide customer service in this way. We also asked for the authority to shorten the standard 6-month response period so we could move the suspicious applications through the system faster. So when you're looking to clear a mark from the system and you know that there's a suspicious application and it's just sitting there for 6 months, it's difficult to see how to get ways out of that. So we wanted to be able to move applications through the system a little bit more quickly. And lastly, we asked for non-use cancellation procedures that were faster and more efficient and cheaper than the Trademark Trial and Appeal Board. Now, the goal of all of these proceedings was to try to clear deadwood off of the register, move applications through the system, particularly the suspicious ones, more quickly so we could improve mark clearance for our customers. Now, Congress, as you know, passed the TMA. They gave us until December 27th, 2021 to implement most of the proceedings in the statute. So we had to move very fast. We normally would do a request for comments, then a notice of proposed rulemaking, and then a final rule in order to set out the procedures for the various provisions, but we didn't have time. So we went out with quick public roundtables, tried to get a whole bunch of input early on, put that into our notice of proposed rulemaking, which of course we issued back in March. We got public comment. Those comments came in by July 19th. We're taking in those comments, and right now we're working on the final rule. And so we'll certainly hope to publish that in November because it has to, at least part of it has to be implemented by December. So the letter of protest procedure, no surprises there, $50 fee. Certainly, it's the same procedure that you've always had in place with just the $50 fee. On the flexible response periods, for those of you who watch this space, we certainly offered 3 different options in the notice of proposed rulemaking on which we wanted comments. We got the comments, and now we're assessing which one that we're going to go with. You know, typically applicants have 6 months to respond to an office action, and usually that in the past that was set when we had, of course, boats crossing the Atlantic with these office actions. Now, these days, it may be reasonable and even necessary for a particularly complex office action. A full 6 months, probably not necessary for all of them. That time lag means those applications are sitting there, and we want to move them through. So we'll certainly see what happens when we issue the final rule. In the NPRM, we said we were going to have a delayed implementation date because you all need to change your docketing systems. We need to change our docketing systems. So we certainly won't be, we're not planning on implementing changes like that in this December, but in the final rule we'll indicate what the target date that we're shooting for is. The one that I really want to talk about in the TMA, though, is expungement and reexamination. So we're working on these new non-use cancellation proceedings. These will move deadwood off the register and facilitate mark clearance. Now, the first of these proceedings is expungement. The target of these proceedings is a mark in a Section 1, a Section 44, or Section 66 registration. That's Paris and Madrid, 44 and 66, a registration that's never been used on some or all of the goods and services identified in the registration. Now, there are 3 types of proceedings in which this new claim or ground for cancellation is available. The first is the petition-initiated proceeding, that's before the director. The second is the director-initiated proceeding before the director. And the third is a cancellation proceeding at the Trademark Trial and Appeal Board. The first 2, let's focus on those. The first 2 types of proceedings before the director may be instituted against a registration in that window of time between year 3 and year 10 of the registration, only in that window of time. The third type of proceeding before the board can be asserted. It's different. The timing is different than the first 2. The claim is available before the board anytime after the first 3 years post-registration. It does not cut off at year 10 like the proceedings before the director. So you need to keep that in mind. All of them, the time period starts at year 3, But before the board, it's whenever. Before the director, though, it's year 3 to year 10. Now, I really want to hammer one point home. The claim of expungement is fundamentally different from a claim of an abandonment. As you all know, abandonment requires non-use plus intent not to resume use. Expungement does not require an analysis of the registrant's intent. Expungement is an entirely new statutory basis for cancellation that only evaluates whether the mark was used on the challenged goods and services prior to the date of filing of the expungement petition. It does not evaluate whether the mark was put into use as of the dates required by the statute. That is a question for reexamination, which I will turn to now. So Congress created the second new proceeding before the director called reexamination, and the target here is a Section 1 registration that was not in use as of the relevant date. The relevant date for purposes of a Section 1A application is the filing date. For a Section 1B application, it is the later of 2 dates, either the filing date of the AAU, the Amendment to Alleged Use, or the expiration of time to file the Statement of Use, the later of those 2 dates. A petition to request institution of reexamination proceedings may be filed in the first 5 years of the registration. So that window of time is year 0 to year 5. It's a quiet title at year 5. There are these 2 types of proceedings before the director. You've got the petition initiated and you've got the director initiated. Now, note that I did not have that third category, right, before the TTAB for reexamination like I did for expungement. That's because it already exists. It's what you know and love before the board. This is the ground for cancellation for non-use as of the relevant date. It already exists under Section 14. The TMA reexamination proceedings before the director do not affect the existing non-use claim at the board as to evidence or timing. And I see Bree has come online, so I think you're going to get your code, and then I'll keep going after that.
Yes, please write down this code. The CLE code for this session is the number 2. The word surges, as in what's happening to the number of trademark applications, and the number 5. It is 2 surges 5. Carry on.
Thank you. Okay, next slide. Here we go. Okay. The notice of proposed rulemaking that I hope you all studied very closely, it lays out the matching procedures that will be followed in both the reexamination and the expungement proceedings. So we have proposed a $600 per class petition fee. Certainly that was a point of interest, and a lot of people had comments on that. Any person, it says in the statute, may file a petition requesting that either expungement or reexamination proceeding be instituted. To file the petition, though, the petitioner must have a USPTO.gov account. So we will know who they are because they have their account with us. Does not mean that they have to tell us who the real party in interest is, and we'll get to that. So the petition must include the verified statement, as well as the documentary evidence of non-use. The verified statement must identify the elements of the petitioner's investigation of non-use. Where did you search? How did you search? When did you search? And what did you find as to each source of information relied upon? And the reasonableness of the search and the number and the nature of the sources the petitioner must search will be determined on a case-by-case basis, which makes sense because every industry sector is different. Once a complete petition is filed and has all of the required elements, a courtesy email notice of the filing of the petition will go to the registrant and the registrant's attorney. The petition and the evidence will be uploaded into the Trademark Status and Document Retrieval TSDR system, and it will be made public as soon as that petition has been filed. Okay, once that petition is submitted and is complete, the petitioner is entirely out of the process. This is now an ex-parte process, not an inter-party process. It is the director who decides whether the prima facie case is made based on evidence and information in the petition and the USPTO's electronic record of the involved registration. The director has the authority to institute a proceeding without a petition if the director has his own evidence establishing a prima facie case. If the prima facie case is established, the director must institute proceedings. Now, once a proceeding is instituted, the examiner, as you see here, will issue both a notice of institution and an office action that directs the registrant to respond within 2 months with proof of use of the mark on the challenged goods or services. Now, again, that response period was the subject of a lot of comments in the rulemaking, and so we're looking at that, and you'll see where we landed on the final rule. The registrant has 3 options for the response. The registrant can provide evidence of use. Great. The registrant must rebut the prima facie case with evidence of use, information, exhibits, affidavits, or declarations that establish that the required use in commerce has been made. Second, the registrant can provide evidence supporting excusable non-use in limited circumstances. This is very limited. The statute sets out that this only applies to a Section 44 or 66 registrant in the context of an expungement proceeding. Now, this does not apply in a reexamination proceeding, and it doesn't apply to Section 1. Now, here's why. Some people get upset about that. Well, why can't I have excusable non-use as a Section 1A registrant? Well, this is looking back. When the application was filed, you swore under penalty of perjury that you were using the mark on all the goods and services in the application. You can't obtain a registration with excusable non-use. So if you couldn't obtain it, you can't go back and claim that, rely on that, the declaration that said you had it in use and now say, no, it was excusable non-use. Inconsistent. So the statute, though, let's just stop there. The statute only applies this particular provision to a Section 4466 registrant from a treaty perspective, and it only applies in an expungement proceeding. Now, as to the third option, deletion. Now, the registrant can just simply delete the targeted goods and services, immediate effect. And so then, if any one of these 3 options is chosen and it's all acceptable, then we will terminate the proceeding and we move on. We're done. Now, what happens if this little happy path doesn't happen? What's the next option? Second scenario here. This is where the registrant's response is unacceptable. The examiner will issue a final action that includes the examiner's decision that the registration should be canceled for each good or services for which the registrant did not provide an acceptable response, or if the registrant did not comply with the requirements for a U.S. Counsel rule, with the electronic correspondence rule, or the domicile address rule. So the registrant then has 2 months again to respond to that action with either a request for reconsideration and a notice of appeal. Of course, the request for reconsideration can add more evidence in, and you'd want to add more evidence in there before you go to the board because that's going to be your record at the board. So if that request has all the good evidence of use or deletion, we will terminate proceedings and we're done. We're out. But if it doesn't, the examiner's decision to cancel then goes to the Trademark Trial and Appeal Board, and the regular proceedings will apply, the regular timelines and everything. So the third scenario is when the registrant does not respond at all. No response results in immediate cancellation for the goods and services on which the proceeding was instituted. Of course, we're not canceling the whole registration unless the whole thing was challenged. It's just what the goods and services that were challenged that will fall away. Once the goods and services are ordered for cancellation because of the non-response, a petition for reinstatement is available, but it's only available for an extraordinary situation. All right. And I just happened to look up, the deletion fee does not apply within the context of expungement and reexamination proceeding unless you are also in the midst of an examination of your Section 8 or 71 declaration. So if the deletion fee applies over there, you have to pay it. We are not imposing that fee within the examination process for expungement and reexamination. We want those goods to fall away quickly, and so we can all move on. Okay. And we'll try to get to the question. So let me buzz through the rest of this. Preventing abuse, right? Let's see. Any person can file. There's no standing requirement for the petitioner, right? That's in the statute, but people are concerned about abuse. So we have some built-ins here. The director is the gatekeeper. Director makes the call on whether the prima facie case has been made. Neither the petitioner nor the registrant can appeal that determination. Only if a prima facie case is made will proceedings be instituted. Secondly, estoppel. The statute says goods and services for which use in commerce has already been established in these proceedings cannot be the subject of further proceedings. So That doesn't apply to the board, though. It only applies within this context. So if a registrant survives challenge by providing proof of use, those goods and services cannot be attacked again in an expungement or reexamination before the director. It can be before the board, but cannot be before the director. Thirdly, administrative sanctions. I told you all about our administrative sanctions. So to the extent a petitioner is harassing registrants here, we can sanction them outside of these proceedings through our administrative sanctions. So we could discover through our investigations that a petitioner was abusing, and we could certainly preclude further submissions in any proceeding in front of the USPTO by that petitioner, and we can terminate their USPTO.gov accounts. Now, relationship to other proceedings, of course, the rule proposes that we will authorize suspension of action relevant to the registration. So to the extent there are relevant proceedings going on elsewhere, our normal rules of suspension would apply. Okay, so timeline, what are we looking at here? We are looking at, as I said, for non-use cancellation, December 2021, we will have these implemented there. The other provisions in the statute and the other provisions in the rule will have different implementation dates depending on where we landed, what comments we got. So you'll see that when the final rule issues. And again, I just really want to say, update your registrations. Make sure we've got your owner email address, we've got your correspondence address, so that you get a notice of the filing of these petitions, and certainly so any unused goods and services are deleted. Now, I have a couple of resource slides for you here. And you'll have access to these slides, so I encourage you to go and look at some of these links. These are the initiatives that I was speaking about. You can get more information from our website on those. Okay, so now Dan and I will look at some of these questions and see if we can answer them.
And I can start because I was looking at a couple questions while you
Okay,
were
good.
talking. So somebody asked about how do they contact the supervisor within a given law office. If you go to our homepage on the USPTO.gov, there's a contacts link. If you click on the contacts link, you can navigate to a list of all the law offices and the respective managing attorneys. And if you look at your office action, you'll see which law office your examining attorney was in. And again, I want to emphasize it's very important that you try to work it out with the examining attorney first. That's the process before you go to the managing attorney. So I appreciate your help on that. Also, there was a question about timeframes for, especially with the new timeframes for TMA and how we're acting within the law offices with respect to speeding up our timeframes. The examining attorneys have 7 days to work on a new application, so the timeframes are already extremely low once the case is assigned to an examining attorney. And then as far as the response time period, they have hundreds and hundreds of cases that they're working on at a time. They have a little less than 28 days to work on those cases, and we monitor that closely. And the issue earlier in the year with responses taking longer to getting uploaded and sent to the examining attorneys, that's been resolved. So we're back to under 14 days from when the response is filed to when it gets to the examining attorney. So again, we'll continue to monitor all those timeframes closely so that you're getting timely responses and to any of your communications.
Any more from you, or? I think you got through yours.
I think I did. There were a couple questions about specimens that I think you addressed, at least as far as what we've been doing.
Well, let me start on, we had a question about what are the plans to combat third-party scammers that send out fake invoices to good faith applicants or registrants? And certainly it is something that we're super concerned about. We have received them as well. We have posted from our customers anytime that they get a misleading solicitation, we post an example of it on our website. We actually have, at the end of my slides, one of the links takes you to potentially misleading solicitations. Now, not all of them are, legally, fraud, right? Some of them are on the line. Now, we try to go after the ones that we can where they're imposed, they look like they're us. They look like they're the USPTO. Certainly, though, there's a lot of them, they're right on the line, and that's difficult to do something about. We don't have law enforcement capability. We actually don't have the ability to bring our own lawsuits against folks. We have to go through Department of Justice. So what we try to do is create awareness. We put all these links to these suspicious solicitations on our website, and we're certainly trying to draw attention of our customers to these things. Because we know it's the scourge. We actually also partner with the TM5 partners. So this is China and the UIPO and JPO and the Korean office, to try to figure out how we can spread the word and raise awareness and crack down on these things as well. Next question. Is there a way to report behavior that looks like it is trying to circumvent the domicile U.S. attorney requirements? Like I said, the TM scams at USPTO.gov mailbox is available for you to use. Understand that we are trying to increase our capacity to take in reports and investigate these reports. This is not something that comes easy. This investigation is very time consuming, and it's a lot of skill sets that we don't have a huge amount of in our. We have examining attorneys. They're not investigators. They are not criminal investigators, but we've got a staff that's ramping up capacity to be able to take in complaints and act on them and investigate. And certainly, if we get a deluge of just people, complaining about X, Y, and Z, where it's not really clear on its face that it's a problem, that's going to overload our system and it's going to slow a lot of things down. So if you're going to, use the TM Scams web email box, we hope that it's something that you will do carefully when you have good evidence for us. Now, certainly also the letter of protest process is available. So to the extent that, if, as I said, the letter of protest practice tips page, if you look at that and decide that you have evidence that would warrant that, we would invite you to use the letter of protest procedure and send that in to us and let us know so that we can put relevant evidence in front of our examining attorneys. That would be very helpful. How are you dealing with specimen refusals where the examiner finds that the packaging doesn't look sophisticated and cites it as a mock-up? Most new business owners don't have sophisticated packaging starting out, so of course the packaging won't look the best. Certainly, as you know, we've had guidance in place since 2014 to issue refusals or requests for information with regard to packaging that does not look like it's in actual use in commerce. So to the extent that a business owner has proof that this specimen, shows use of the mark in commerce, then the examiner will take that. And that will overcome the refusal. So I don't know if that's sufficient to answer the question, but certainly we're not out to try to get small business owners and prevent them from getting their registrations. So certainly we think that could be overcome. A question, how do we flag some of this fake specimens that are submitted? I think I just answered that question. Let's see. There seems to be a complaint about entities committing unauthorized practice of law. Certainly, we're looking into that when there is, evidence that we have of widespread rule violations by these entities. Certainly, we will look into whether we can issue any sanctions and try to disrupt that business model. But of course, there's a lot of evidence that is required to determine whether unauthorized practice of law is being committed. So we're certainly looking into that as part of our special task force investigations. Let's see. Okay. Somebody noticed that our orders for sanctions. We have a lot of show cause orders, but not a lot of sanctions orders. We're working on that. I guess actually that's probably not a great response. We're aware of that, and we're certainly trying to figure out how to prioritize our efforts. A lot of the show cause orders that you saw, those applications have already been abandoned or have fallen away for various reasons. But we do want to go through and try to make sure that we are following up on each of the show cause orders with a final order for sanction where it's warranted. But as you can imagine, we have a lot on our plate with regard to these investigations, and we're prioritizing where we can to try to get at the bigger problems and try to prevent a lot of problems for our applicants coming in. A dashboard would be Awesome. That sounds like a great idea. And actually, just yesterday, I asked my folks to look at a way to try to get a better looking page that was a lot more user friendly. So we're on it, and that is underway right now. Let's see, addresses. What are the technical issues that prevent implementation for identity? Well, commercial mail drop receiving mail drop addresses during the initial application. One of the there's a lot more than you would think. I came into this job in January, and there's always something that makes it something IT related difficult. Certainly, we are working on how to do that. We have a flag now. Whenever we compare all addresses in our files with the USPS list of address, it's called the CAS, and we're trying to make sure that we put that in front of our examiners. If we start blocking applications being filed because the address doesn't fit some sort of template, we could get into difficulties there. So we're looking for ways to try to take in an application and then fix the address, and we're working on ways to do that. Actually, that's my plan the last couple of weeks has been to try to have a phased approach in this. Let's see. There's a question about TMA. If TMA reduces the applicant's time to respond to an office action, will similar requirements be imposed on examining attorneys?
Yeah, that's what I just talked about with the
Okay.
time frames for the examining attorneys to work on their cases.
Okay.
Okay.
All right. So it is now 12:10.
Okay.
I know that my audience would listen to you all speak basically for the rest of the day if you wanted to stay and hang out with us. I know you have like actual jobs that aren't speaking for us. So I really, really do appreciate both of you coming here and joining us. The session has been incredibly helpful. If you want to pop into the chat and just see all of the thank yous from all of my attendees who are
I
so
just want to
grateful
say
to have
one
you,
thing, because I was
please.
just scrolling through and I saw when somebody asked what are the PTO efforts on, how to deal with some of the bigger issues that were flagged in an Office of the Inspector General report. I want to direct all you guys to come here on September 23rd. I'm doing a webinar on our register protection initiatives. I have an hour and a half to spend to tell you all the things that we're doing in just exhaustive detail, and I would invite you to come and join me for that. We'll have the ability to take some questions there. It's just me, so an hour and a half, I can fill an hour and a half, no problem. So I invite you to come join me and hear in exhaustive detail all the things that we're doing. So sorry, Bria, I just wanted to address
No,
that
I really appreciate that. Can you send us the link so that I can get that to everybody?
Yep, will do.
All right, beautiful. Thank you so much. I will share that link as soon as I get that from Amy. We do have a break for the next 20-ish minutes, about 18 now. So go grab a bite to eat. I will see you back here at 12:30 for Put Your Money Where Your Market Is, how and where to market your firm to maximize ROI. So thank you so very much, Dan and Amy. This was absolutely wonderful. And I think the entire audience, like, oh, wow, okay, I understand this thing a whole lot better. So thank you very, very much.
Happy to be here. Thanks.
Our pleasure.
Thanks.